Hello. We continue with our final lecture of week one, a short discussion of decision making on the Supreme Court, also called methods of constitutional interpretation. And you want to take a look at table 2-1 in your textbook. So the text notes that the Supreme Court doesn't simply make legal decisions, but that other factors influence the justices. Some of these factors are political, ideological, and strategic. One example that the text gives is Rule 10. So the court lays out for us some of the reasons it will grant review to a case, and we discussed this in our last lecture. But it doesn't grant review to every case that has those characteristics or that's considered cert-worthy. It couldn't do it. There are too many. So how does it decide? Furthermore, the court grants review to some cases that are not cert-worthy. So that raises a really important question. If the court doesn't follow its own rules about the legal worthiness of cases, it decides to grant certiorari to some that don't have characteristics, and then it doesn't grant certiorari to those that do. What else determines whether it grants review? The text notes a number of factors, and these are the ones we will discuss, and here they are here for you. We'll discuss the legal model, judicial restraint versus judicial activism, individual characteristics of justices, and justices' attitudes. Okay, so I'm sorry, and the last one, of course, is strategy or strategic variables. So let's begin our discussion with the legal model. The legal model of judicial decision-making posits that the decisions of justices are all legal in nature, that other concerns are inappropriate, and that judges and justices make decisions based on their views of the law. There's a problem with this model, though, and we've already seen it in our discussion of Rule 10. The idea is not a bad one. Obviously, the law is important to judges. They are educated in the law. They respect consistency in law. They value stare decisis, which simply means let the decision stand, or in other words, it refers to following precedent. They value federalism, the role of the states, the power of the federal government, etc. So law is important, but law doesn't tell the whole story. There are some very important aspects to this model. Those who advocate for the legal model insist that a good judge decides cases using a literal interpretation of words and uses plain meaning of words to decide what the Constitution means. I've always thought that this is a good place to start interpreting statutes or the Constitution. I don't think it's always the best place to end. Literalists come in three varieties. Those who argue for original intent begin any inquiry by asking what the framers wanted. What was the original intent of the framers? Once again, I think this is a good idea, a good place to start. But there are a couple problems. First, if the framers wanted judges to use original intent all the time to interpret the Constitution, why didn't they say so? Why didn't they put that into the Constitution in Article 3? In fact, several framers say exactly the opposite. Thomas Jefferson said that each generation was responsible for interpreting the Constitution for itself and should give no weight to what he thought. Second, the framers didn't always agree on what their original intent was. Some had very different views of the Constitution. And this leads us to the example in Table 2-1. Do you notice that in the example under original intent, both sides in the gun control debate refer to the framers' wishes? So how does that help? Not much. The second type of person who uses the legal model, a judge applying the legal model, is a person who uses original meaning. This variety starts with what were considered the meanings of words used in statutes or the Constitution at the time it was written. Rarely, however, does any individual using original meaning really want to stick with it. They wander off into things like fair implication. I mean, everybody's heard the standard example of the president is the commander-in-chief of the armed forces, and the armed forces that existed at the time were the Navy, the Army, and the Marines, but there was no Air Force. So by fair implication, I think even someone using original meaning would say, well, armed forces has been extended to mean Air Force. The third type of person is the textualist. Former Justice Antonin Scalia is an example of a textualist. He believed that there were words in the Constitution, and if there were words in the Constitution, then we could interpret them. He often employed original meaning to begin that interpretation. So judges are also concerned about using their power appropriately. And we've already discussed political questions a little bit. Remember, we said political questions are questions the Supreme Court doesn't think it's fit to resolve or to answer. We have already discussed that a little bit, and there are some questions that the court doesn't feel competent to decide. Part of this concern about the use of power involved judicial restraint, judicial activism. Political questions doctrine is an example of the court restraining itself. These two, though, judicial restraint, judicial activism, are kind of loaded terms. Today we think of liberal justices as judicial activists and conservative justices as judicial restrainists. And yet the conservatives dominating the courts of Chief Justices Rehnquist and Roberts have struck down more state and federal legislation than any other courts in our history. That's what an activist court does. So it seems to me that these two terms are usually used to justify any decision you think is best. And they really don't help us understand the difference between a conservative justice and a liberal justice. Do you want a decision that, quote, respects state power? Well, then you argue for restraint. Do you want a decision that preserves a new right or limits governmental power? If so, then you strike the legislation down and talk about how you are properly interpreting a constitution when what you really are doing is overturning the wishes of a popularly elected majority as an activist judge. More than any other terms, these are the most politically loaded terms when it comes to talking about the Supreme Court. Also, justices have particular backgrounds and experiences. They come to the bench with certain characteristics. Diversity in the bench is a good idea, I think. But primarily, this is so because we don't get new judicial doctrines from diverse people. We get the ones we have applied more equitably. Political scientists group these characteristics of justices into attitudes and ideology and strategic behavior, both internal and external. Now, justices' attitudes influence their behavior, and that's pretty clear. And these attitudes are often organized under the heading ideology. There is no doubt that ideology influences decisions. In fact, the law leaves room for multiple valid interpretations of statutes and the Constitution based on various ideologies. These multiple valid interpretations often get organized around liberal or conservative ideology. So I would argue that it is inappropriate for a judge to rely. I would not argue that it is inappropriate for a judge to rely on his or her ideology at times when the law provides room for it. Also note that much of our law is settled. A stop sign is a stop sign. Okay? Nobody's arguing about stop signs. Some people have different interpretations of what to do when they approach one of these stop signs. But there is no doubt as to law about how one is supposed to act at a stop sign. There's no conservative view of these laws or liberal view. It's only when we get to the new unsettled areas of law or when we experience challenges to the law from new technologies or economic changes or threats like terrorism or changing social roles of people that ideology becomes a valid influence on the decisions of judges. Finally, there are strategic concerns on the court. Strategic concerns simply refers to the fact that people behave differently in groups. Let me give you an example. Let's say you are a conservative justice who wants to limit the power of the states to regulate guns. You have a choice in any particular case. You can stick to your principles and end up in the minority much of the time, or you can moderate your position so that it is more acceptable to some of your other less conservative justices. Why would you do this? Because according to the rules of the Supreme Court, you have to get 4 other justices to join with you to form a majority and decide a case and thus influence the state of the law. So you strategically make accommodations and compromises so you can have some effect on the outcome rather than none at all. That's called strategic behavior. By the way, this is the way life works. Anyone who has been married doesn't have any reason to complain about judges and politicians compromising. Marriage is one big compromise. And people who decide not to compromise on their principles or don't have any principles don't stay married very long. So that was an example of an internal strategy internal to the court. But the court also has to consider external strategic concerns. How will Congress react to this decision? How about the president? Will this decision harm the public image of the court? Sometimes the court will consider how other courts handle similar problems and decisions. This shows up in Table 2-1 as polls of other jurisdictions. This sometimes poses a problem because polling other jurisdictions really has no constitutional validity. Nothing in the Constitution says that we should consider its words in light of how England, France, or Argentina have handled similar social, economic, or security issues. There are a few other methods of constitutional interpretation that you should look at. Structural analysis is particularly interesting to me. It makes a good deal of sense to assume that the Constitution should make sense across all its parts and provisions. The Constitution isn't a suicide pact. The use of words in one place shouldn't be used to frustrate and derail the entire system. A machine should work smoothly, its various parts functioning to achieve its goal. If we think of the Constitution like that, we have to interpret specific words and clauses in light of the overarching goal of the Constitution to create order, provide security, structure a functioning government, and provide a set of rights that manage our personal relationships and interactions with others. Well, that was our tour of decision-making in the Supreme Court. These lectures often raise more questions than they answer, but I hope that was helpful for you in beginning to understand this chapter. Thanks very much for your time.